Good day, Athenians. Welcome to our seventh topic under the subject regulatory framework. The seventh topic will be the Republic Act 8293 or the Intellectual Property Code. This is the law that governs and regulates the ownership of individuals on intellectual properties. Now, Republic Act 8293 or Intellectual Property Code was enacted by Congress following the mandate of the Constitution under Section 13, Article 14, which mandates the state to protect and secure the exclusive rights of scientists, investors, artists, and other gifted citizens to their intellectual property and creations, particularly when it is beneficial to the people for such period as may be provided by law. So the Constitution already mandates the state to provide protection to intellectual property. But as to the period or the coverage of this protection, it will be determined through the enactment or promulgation of a specific law. Thus, Congress passed Republic Act 8293. The Intellectual Property Code, Section 2, stated that the state recognizes the importance of intellectual industrial property to the development of domestic and creative activity in facilitating transfers of technology and attracting foreign investments and ensuring market access for the local products. Okay? So the basic principle of the Intellectual Property Code or Republic Act 8293 would involve two terms. One is the national treatment, and the other would be the most favored nation. You will encounter this one when we will discuss in details the different intellectual properties and their detailed provisions as well as how they are protected. So when you say national treatment, a member country shall accord to the nationals of other member countries treatment no less favorable than it accords to its own national with regard to the protection of intellectual property. So by joining now international organizations and harmonizing rather our own intellectual property laws with respect to the international community, the Philippines now, by passing Republic Act 8293, vowed to provide the same protection to nationals of other countries, meaning citizens of other countries or foreigners, the same treatment that it will give to Filipinos with respect to the protection of an intellectual property. So it was worded as no less favorable, meaning equal treatment. Now, you'll hear a term later on we call most favored nation. When you say most favored nation, any advantage, favor, privilege, or immunity that has been granted by a member state, meaning a country, to the nationals of any other country shall be accorded immediately and unconditionally to the nationals of all other members. Meaning once you've accorded the same kind of privilege to, say, an American, that particular privilege shall be accorded immediately and unconditionally to, say, a British national or a Japanese citizen. Because you've already accorded the privilege to the national of another country. Okay? Now, in intellectual property code, you will also encounter what we call a technology transfer arrangement. A technology transfer arrangement pertains to contracts or agreements involving the transfer of systematic knowledge for the manufacture of a product, the application of the process or rendering of a service, including management contracts, and the transfer, assignment, or licensing of all forms of intellectual property rights, including licensing of computer software, except computer software developed for mass market. that is provided under Section 4.2 of the Intellectual Property Code, a copy of which was provided inside your diagram. Now, in the nature of a voluntary license contract, um, the nature of a technology transfer agreement, it is a contract between an intellectual property right owner. If you are an intellectual property right owner, meaning you own the intellectual property, you are called a licensor because you are licensing now another for the use of your intellectual property. The second party is called the licensee. The licensee is the one expected to make enjoyment or to use your intellectual property upon your agreement or approval, or upon a license agreement, or what we call a technology transfer agreement. The contract will authorize now the licensee to commercially exploit the same intellectual property right under a specific term or specific terms and conditions. Now, with respect to intellectual property class, what Article 39 of what we call TRIPS, okay, um, there is a term called undisclosed information. And undisclosed information is a secret in the sense that it is not as a body or in a precise configuration and assembly of components generally known among or readily accessible to persons within the circles that normally deal with the kind of information in question. This particular undisclosed information has a commercial value because it is a secret, or has been subjected to reasonable steps under the circumstances by the person lawfully in control of the information to keep it a secret. Now, those trade secrets are of privileged nature. The protection of industrial property encourages investments in new ideas and inventions and stimulates creative efforts for the satisfaction of human needs. It increases what we call the motivation to find solutions to our problems, to, to develop creative efforts to quench now human thirst for improvement, for comfort, for delivering new heights of technology that will what? Um, Solve our health problems, to solve daily problems, to develop new technologies that will bring new comfort to our lives. And because of the protection being given, a lot of people are motivated to discover these new inventions, this new technology, these new creative efforts. And that is the primary reason why intellectual property code has been enacted in the Philippines, to stimulate Filipinos to constantly develop, to constantly search for new ideas, for new solutions, because the law here provides protection for that. Protection that others may not steal it, that you enjoy monopoly towards the or control towards the enjoyment, towards the exploitation and the use of your newfound technology or your newfound creative effort or discovery. Because of the intellectual property code class and because of this protection, it speeds up transfer of technology and industrialization, and thereby bringing social and economic progress to our community. In fact, in Air Philippines Corporation versus Penswell, GR numbers 172835, ruled by the Supreme Court, December 13, 2007, the High Court provided that the protection of industrial secrets is inextricably linked to the advancement of our economy and fosters healthy competition in trade. Okay? Now, let us now proceed to the definition of terms, the different terms under intellectual property code. Now, we have the different intellectual property rights and their corresponding definition. The first of the intellectual property rights would be copyright and related rights. This exists over original and derivative intellectual creations in the literary and artistic domain, protected from the moment of their creation. Trademarks and service marks refer to any visible sign capable of distinguishing the goods. If it pertains to distinguishing marks of goods, it's called trademark. And if it means distinguishing services, it will be service mark of an enterprise and shall include a stamped or marked container of goods. Geographic indications refer to any indications which identify a good as originating in the territory of a member of the agreement. It will say member class, it means nation, a member nation, or a region or locality in that territory where a given quality, reputation, or other characteristics of the good is essentially attributable to its geographical origin. The definition of geographic indications is provided by Article 22 of the Trade-Related Aspects of Intellectual Property Rights, or TRIPS Agreement, which is an international covenant by member states. The next intellectual property right that you will encounter while reading over this particular law or code is industrial designs. Industrial designs are any composition of lines or colors or any three-dimensional form, whether or not associated with lines or colors, provided that such composition or form gives a special appearance to and can serve as pattern for an industrial product or handicraft. It must be new or ornamental. Another property right would be patent, which is any technical solution of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable. Take note, later we will discuss in total these three common types of intellectual property rights, and we will discuss in details patents. And you'll know that these three elements will determine if that particular discovery or technical solution is patentable. If it is new, it involves an inventive step and is industrially applicable. It may be or may relate to a product or process or an improvement of any of the foregoing. Another intellectual property right will be layout designs. This term is synonymous with topography and means the three-dimensional disposition, however expressed, of the elements of at least one of which is an active element and sum of all of the interconnections of an integrated circuit, or such a three-dimensional disposition prepared for an integrated circuit intended for manufacture. You will encounter layout designs if you have, I think, industrial technology in high school. I'm not sure if it's still available in program, but during my time, there's an industrial technology subject elective when we're in fourth year, and electrical circuits will be their final subject requirement for layout designs in one of my classmates. So I didn't take industrial design kasi, so but that is one of the subjects. They will create an integrated circuit, more of like a three-dimensional circuit that will show you the flow of current, and they'll show that the particular model or circuit will work by, say, by allowing the light bulb to work or to get light, or so to speak. Now, another intellectual property right would be protection of undisclosed information. This is the protection of information lawfully held from being disclosed to, acquired by, or used by others without their consent in a manner contrary to honest commercial practices, so long as such information first is a secret, in the sense that it is not generally known among or readily accessible to persons within the circles that normally deal with the kind of information in question. Second, it has commercial value because it is a secret. Okay? And third, it has been subject to reasonable steps under circumstances by the person lawfully in control of the information to keep it a secret. So those are the elements to determine whether that particular information can be protected from unlawful disclosure, or lawfully held from being disclosed to other individuals. Now, another will be the term trade secrets, which is a plan or process, tool, mechanism, or compound known only to its owner and those of his employees to whom it is necessary to confide it. The definition also extends, the trade secret term extends to a secret formula or process not patented but known only to certain individuals using it in compounding some article of trade having a commercial value. An example will be the syrup used for the manufacture or bottling of Coca-Cola products, yung Coke. That's a trade secret. Kasi kapag you will apply for a patent later on, you will have to disclose the composition kasi. So if you're keeping it a trade secret, and chances are it is not patented, not uh, protected because you're keeping it as a secret. Eh, right? Applying for a patent protection is actually would actually mean that you are actually disclosing that particular formula. Another will be any formula, pattern, device, or compilation of information that is used in one's business and gives the employer an opportunity to obtain an advantage over competitors who do not possess the information. So it could also be a compilation of process or procedures that is unique to the business, and that particular procedure allows the business to perform or to operate better than their competitors, or to take a commercial advantage over their competitors. So that could be covered as well by the definition of trade secrets. This particular definition of trade secrets extending to formula, pattern, device, or compilation of information was also enunciated by the Supreme Court in the same case, Air Philippines Corporation versus Penwell Incorporated. Okay? So those are the different terms or definitions that you will have to watch out while we discuss the seventh topic on intellectual property code. Up next, we will discuss the first type of intellectual property right under regulatory framework, which is patent. So we will first discuss patent in the next episode, here only in our discussion under the regulatory framework.